The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
You may be seated. We have three cases for submission this morning. The first is State of Iowa versus Fordyce. The second is Youngblood versus Youngblood. And the third one is Olatunde versus Iowa Department of Human Services. They are all oral. We will take a recess between the second and third case. And we're ready for the arguments in State versus Fordyce. And it's Mr. Kodiaga. Come on up and... Oh, that's him?
No, Chris Kragnes.
Yep. And the first is Mr. Kragnes. I'm sorry.
Good morning, Your Honors. May it please the Court. My name is Chris Kragnes. I represent Steve Fordyce in this matter. That pause represents approximately 4 seconds, the time in which the District Court and the Iowa Court of Appeals have determined that Mr. Fordyce had an opportunity to choose an alternative course of action related to this incident. He had to choose during this 4 seconds, according to the District Court and the Iowa Court of Appeals, while a 6'3", 275-pound man with a known meth history was charging at him, saying, not just that I will kill you, I will fucking kill you. How do we know this? Because it was caught on audio. This isn't a question of his actions being unknown. This isn't a question of his actions being testified to by other people. We have a snippet, the last 20, 30 seconds of this incident. Your Honors,
the snippet, doesn't your client say, doesn't the other gentleman, the victim, say, go ahead, do it?
yes, he does.
Well, doesn't that suggest that maybe your client had time to contemplate another course of action?
Actually, no, not at all, Your Honor. And in fact, if we look at the snippet and the timing that we're talking about and the findings that we had in this case, there was a discussion related to this altercation, this yelling back and forth. And at some point in time, Mr. Harrington was informed or noticed that Mr. Fordyce, who was a lawful carry holder permit, had his gun. This seemed to agitate Mr. Harrington, made comments to the effect of, you better know how to use that. Go ahead, things like that. But the last comments that we have are those threatening comments as he's charging him. I would submit to this court, much like a defendant doesn't get to come before this court and say, he said some really bad things to me, so I shot him. Words are not enough of a provocation. Why is it different then? If someone is yelling at you, if someone is involved in an altercation and you're where you're lawfully supposed to be, you're standing on your sister's property, you're not engaged in the altercation, you're not agitating anyone other than apparently your presence.
You make it sound like he's just there at a birthday party or something, but didn't he turn around and want to rumble at just his own presence? I mean, he got away from a bad situation and came back, correct?
Yes.
And so it's not just that he was somewhere. I mean, there was already at that point some agitation. Isn't that what the record shows?
The record shows that there was some agitation, Your Honor. However, to classify Mr. Fordyce's conduct as wanting to rumble is absolutely not contained within the record, not supported by the evidence that occurred at trial. Mr. Fordyce backed out of a driveway. Mr. Harrington flips him off. At the time, he doesn't know what it's about. Mr. Fordyce stops, kind of gives that look that I think all of us have probably given to someone at some point in time of, and? At this time, because he stopped, Mr. Harrington comes and charges his vehicle, puts his hands on his vehicle where Mr. Fordyce is present and has his children. What does Mr. Fordyce do at that time? He leaves. He circles back around. He doesn't park on the street. He drives literally up onto the lawn so that he can tell his sister, hey, Donald's apparently got something going on. And at this time, his sister and her friend decide, and obviously making a poor decision, decide to go see what's going on. Mr. Fordyce follows behind in an effort.
Before he follows behind, he makes sure his kids are secure in that pickup and locks it, right?
He leaves the children in the vehicle and locks the door, absolutely.
And then he goes as far on that property line as he can go without crossing over. Would that be a correct assessment of the facts?
Absolutely. And I would submit now to ask the court, what's wrong with that? And keep in mind that the Court of Appeals has already determined that he did not continue the incident. I would submit that that's a discussion related to continuing the incident. The problem that I foresee in this particular case, as I've indicated in the written arguments also, is we're putting a burden on someone that he didn't do anything wrong. Is there something wrong with going with your relative to make sure that they're okay? He didn't ask Mr. Harrington to effectively go crazy. He didn't ask Mr. Harrington to make these threats. He didn't ask Mr. Harrington or interact with him in any way, shape, or form to instigate an argument, a fight, a rumble, anything of the sort. But what he got in return was a 6'3", 275-pound man yelling at him and charging him, saying that he was going to kill him.
Can you explain to me the issue related to, is it Capelson's testimony, the expert with respect to kind of the distance that somebody could cover over a period of time and how that would affect your ability to retreat?
Absolutely, Your Honor. Mr. Capelson testified. He talked about the 21-foot rule, the time in which it can take and a human being can traverse 21 feet. As it turns out, and the testimony that we had in trial was approximately 4 seconds. It seems to correspond within that time frame. And I apologize, Your Honor, I didn't get completely to your finishing your question, and it ties with Judge McDonald's question. Mr. Harrington started at the top of some stairs. He was up on a porch when some of this discussion was occurring. And then all of a sudden, as testified to, he snapped and he charged and he started covering that distance. And Mr. Fordyce apparently is supposed to, while having a weapon, turn his back on this man. Instead, what he did, and as what Mr. Capelson testified to, he did what a permit holder and a lawful citizen with a firearm should do. He defended himself from somebody that was coming at him. And the evidence will show, and the evidence did show, Mr. Harrington was shot from a distance of approximately 2 to 4 feet.
Should our focus be on his self-defense, or are you also relying on his defense of his sister? And if so, what evidence is there that Harrington threatened his sister?
Your Honor, and for the purposes of further review, I specifically focused on the alternative course of action. However, I do believe that they are intertwined and that there is a meshing of those. In light of the evidence that came in at trial related to the ongoing discord, would be a good way to put it, between this particular family and the neighbors, and considering that this altercation started over some fruit snacks. That's what occurred here. In light of Mr. Harrington's conduct, to me, and I think the evidence reflects, it's more than fair for Mr. Fordyce to consider, while he's watching this interaction occur, and now having to process this person's charging me at this short distance and can cover it this far, if I leave, I'm leaving my sister and her friend behind.
Should we focus just on that 4 seconds or take a broader view of the entire incident?
I think the focus has to be on the 4 seconds. And the reason for that is, I mean, sure, that might not come as a surprise. Arguing that is certainly beneficial to my client. But that's not the reason. The situation is, are we going to tell citizens that if you happen to be in a verbal altercation that then turns violent, that you didn't cause, that you didn't turn violent, you now don't have an opportunity to argue that you're defending yourself because, well, you should have left.
But isn't this a substantial evidence question? And, you know, we could view the evidence your way. It sounds like the jury viewed it the other way. I mean, we can't overturn this verdict, even though we may think your way is right, as long as there's some evidence to support the jury verdict. And that's my problem with it, with trying to undo the verdict.
Certainly, and respectfully, Your Honor, I appreciate and I agree with the substantial evidence argument. However, in this particular case, with the trial to the court, we have the benefit of the findings of fact and the conclusions of law. We have written findings. This court gets an opportunity now to actually look at what the district court relied upon. There is not substantial evidence in this record to rely on a finding that there was an alternative course of action. It does not exist. And the district court, a thorough reading, even a quick reading of the court's argument, shows that this was a tortured process, quite frankly, to come to a conclusion of voluntary manslaughter. And I would submit to Your Honors these two inconsistent statements from the district court's order. Mr. Fordyce had the requirement, according to the court, in quote, once he was aware Donald was coming towards him, he had to seek an alternative course of action. That's why the 4 seconds comes into play, Judge Waterman. That's why we focus on the 4 seconds. However, in the same ruling, the court says, however, defendant did not initiate the process to draw and shoot his gun until after Donald charged at him. Yet again, instilling the 4 second situation. But those two comments themselves, if we look at the facts, don't support an alternative course of action. What they support is somebody had to make a split-second decision and did. And yes, that decision turned out deadly, but it wasn't the fault of Mr. Fordyce in any way, shape, or form.
Didn't the evidence show, though, he was shooting while he was backing up? I mean, I thought I read that he was, where the shell cartridges were, you can see he was backing up.
Absolutely, which clearly supports the theory and the concept that Mr. Fordyce did no wrong. It's not like he continued forward towards Mr. Harrington. Upon Mr. Harrington charging Mr. Fordyce, he did what he was trained to do.
Couldn't the court find that when he was backing up, he didn't have to shoot? I mean, I think that's what he found.
Well, I think what the court actually found is that he could have apparently left this situation sooner. The court specifically was finding in the findings that the backing up supported the fact that there was an opportunity or supported Mr. Fordyce's claim that, hey, this is how quickly this guy was coming at me. And the district court was specifically refuting, I believe, the testimony of Samantha Harrington and her view on what occurred at that point in time. To further answer your question, though, Your Honor, it does support Mr. Fordyce was retreating. And at a point in time that he could not retreat safely without harm to himself, without possibly losing his weapon, without additional harm, he then fired. It is indisputed. Donald Harrington was between 2 and 4 feet away from Mr. Fordyce at the time that he was shot. Not 20, not 50, not 5. 2 to 4 feet away. Where are you supposed to go? What are you supposed to do? And I will absolutely, and I'll rely some on the written briefs. When you are lawfully carrying a gun, you have the same duty and responsibility that the police officer has, not to let someone get that firearm from you. And make no mistake, one person was lawfully doing things and one person wasn't. Mr. Fordyce was lawfully carrying that firearm. You don't turn your back on somebody, which is why he was backing up while shooting. You don't turn and run and take this same person that already attacked your vehicle with your children in it back to where your children are. You don't do it.
Could have gone somewhere other than where his children were, couldn't he?
Not really, Your Honor. The layout and looking at the photos and where the driveway is, where the house is, could he have, in theory, I suppose, tried to cross the street and retreated that way? I suppose we could say that he could have.
Isn't it more reasonable to assume somebody in danger would not intentionally take themselves towards their children?
I'm not certain of that. I've never been.
I said reasonable.
Certainly. The situation is, though, I think reasonable might be we're going to go to where we think we're the safest, which would have been the entry of that house again. He had no cover if he had taken any other route. Had he gone any other route, he'd be out into the middle of the street. He would have been, I don't know, traffic. Who knows? But he did not have any cover at that point in time. Stepping away from that, though, he didn't have the time to turn his back when he had to fire at somebody that was 2 to 4 feet away. He didn't have the time to turn around. He would have left himself exposed and vulnerable at that stage. Would this case be different if Mr. Harrington had soot marks on his body to show that he'd actually come into contact? Does Mr. Fordyce have to wait for that to occur? I don't believe that that's reasonable either. And I don't think that that is what we want to stand for when we're going to allow our citizens to lawfully apply to carry a firearm and carry that firearm.
Am I correct that there's a self-defense and defense of others, and the court ruled out defense of others because the two girls kind of brought it on?
It did.
Okay, so we really don't need to talk about alternative course with the defense of others. Am I correct?
Correct.
So we've narrowed it down to just self-defense.
Yes.
And the court said you didn't bring it on at that moment. Maybe initially there were some transactions going on. But that's where the alternative course of action argument is, just regarding self-defense. Would I be correct?
Yes, Your Honor.
Thank you.
All right. Thank you.
Thank you very much. We're not ready for the argument of the state.
Mr. Chief Justice, and may it please the court, I'm Israel Kodiaga, Assistant Attorney General, representing the state. Steve Fordyce was not justified, as this court's questioning has indicated. And I'll start with the questions from Justice Waterman. Should we take a broader view of these entire incidents? And I submit that the answer to that is yes. And that's the view that the court took here. The district court found that he continued the incidents. He started or continued the incidents by coming back and pretty much going with his sister and a friend over to Donald and Samantha Harrington's place. When he went there, the district court looks at this case and says, circumstantially, his motive or his way of going there, when he stands and looks at an event where he knows it's pregnant with conflict, he's just had a fight with this guy, and he knows that he's coming back and standing right on the edge, watching as his sister and a friend are fighting these people, that he is continuing the incidents. He is in any way, in any shape or form, he's lending some countenance to what is going on at that point in time. And we asked this court to affirm on that ground that the district court found that he did continue the incidents. Now, if we move to the alternative course of action, clearly there was lots of alternative course of actions that he could have taken. Again, the district court, if you look at this from an entire framework or a broad view of the incidents, we can see that he could just have left. If he had a problem with this guy, he did the right thing at the first time when this guy comes to his vehicle and Donald comes to his vehicle and he drives off. That was the right thing he could have done. He was exercising an alternative course of action in a conflict and driving off. But instead, he makes a U-turn and he comes back. He comes back, he tells his sister that your neighbor has gone nuts. Then he doesn't leave it there.
Mr. Kodiaga, I know how to pronounce his name, by the way, because I had you in class many years ago, I think it was. How far away was the porch where the victims started from and where Mr. Fordyce was? What was the distance? What does the record show on that?
And this court will be able to look at, I believe, State Exhibit B1 will be able to give a picture of the porch. The record was never, there was no testimony to it. My estimation will be that it will have been a distance of maybe 15 feet away from the porch to where Mr. Fordyce would have been standing, or 14 feet, give and take. However,
would you agree that it's the state's burden to prove with respect to alternative course of action that the alternative course cannot pose a risk of danger to the shooter in this case? Is that right?
That is correct, that if he has to take an alternative course of action, he can only take an alternative course of action that will not pose a risk. But he cannot...
where is the evidence that him retreating would not have posed a risk to his safety?
So if we take the time frame when he is standing and watching Mr. Harrington, right? And Mr. Harrington is mad at him. Mr. Harrison sees him, starts yelling at him. He doesn't back up at that point in time. He doesn't decide to leave at that point in time when he realizes that Donald is mad at him. It is not, I believe the district court says Donald moved quickly. I do not believe the district court said that for sure it was 4 seconds that it happened. There was testimony to the effect that there was 4 seconds on an estimation of one of the witnesses. However, the district court says he moves quickly. Within that time, he is saying a lot of things. Donald says, you want to fight, you want to shoot me, you want to kill me, get it over with. Our argument is that there's a bigger time frame that happens when he is communicating his hyperbole language to Fordyce at that point in time. When he says, I'm going to fucking kill you, he is talking. And as he moves, he's moving towards Mr. Fordyce at that point in time. All that time, Fordyce could have left. Once he realized that this guy was still mad at him, that there was still a fight that would have happened here, he could have left. And it's not true to say that he could only have gone back to his vehicle. This was a wide open street. This was a wide open housing area. He could have gone anywhere that he wanted to go. He could have crossed the street. He could have run away.
But there's no evidence that, I guess, you're saying these things. He could have left. He could have fled. But where's the evidence that he could have done so safely? So we have expert testimony indicating how quickly somebody can cover a certain distance. Mr. Fordyce is stationary. I mean, you know that when somebody needs to turn and move and somebody already has momentum coming towards you. I mean, is the state's position that Mr. Fordyce's duty here was to risk being caught and then beat? And only at the point where he's being beaten, then he can discharge his firearm?
There's no evidence that the 21-foot rule that the expert witness talked about looks at the reaction time of a police officer when someone is armed and someone who's armed is approaching him, that the officer has 21 seconds to be able to safely shoot that person before that person gets to him and stabs him or hits him with an object. Here there was no testimony to that effect that Donald was armed, had any weapon, that he was going to do anything that he was saying. Of course, he was saying a lot of things, but there's no testimony that he actually actualized any of the things that he was going to do. And within this time frame, he could have retreated. The law required Mr. Fordyce to still step back, exercise some retreat, and only when retreat was not feasible or possible is when he can use deadly force. Here instead, Mr. Fordyce chose to stand and wait as this man was talking to him and never took any action to even step back. Only
Shift gears if I could. We had this situation where there were about 11 months that elapsed, nearly a year between, I guess, the trial of the case and the verdict that was rendered by the district court. And, kind of the word of wisdom for a defense lawyer, criminal defense lawyer, is when the jury is out a long time, they're always going to come back and get you with something. And isn't it kind of troubling that you have this 11 months that passed? Doesn't that mean maybe we should scrutinize the verdict a little more closely than we would in an ordinary review of a bench trial?
I don't think so. I think the district court does explain its rationale for why it took a lot of time. And the district court says, I took a lot of time because I was looking at this evidence really keenly. I wasn't playing around with it. I gave it all the due process that it deserved, and I took time. I don't think this court should second guess on a substantial of the evidence question. I think the court should look at the district court findings of facts and be able to say that, well, the time does not matter. Whether it took 2 months, whether it took 6 weeks, whether it took 2 weeks for this court to arrive at this verdict. The court gave its reasons for why it took its time to arrive at the verdict. It's 11 months. And, of course, defendant is not arguing here that that was of any prejudice to him. In fact, I will submit that he got a break maybe for this court by taking that much time, that he got a break because the court could have convicted him here.
But isn't the defendant sort of raising an independent kind of due process issue based on the amount of time that elapsed? Isn't that right?
He does. I don't think he's raising it to this court, and he's not asking this court to rule on the due process. He believes he loses on that ground at the Court of Appeals and at the district court level. But our position would be, even if this court were to look at it, defendant did get a break. This court would have convicted him of murder one based on the facts of this case. However, the court ended up scrutinizing this evidence. He got convicted of manslaughter. I do not believe that this court would be doing its duty if it went back to the evidence and viewed it in the light most favorable and made a claim that the defendant is not making on what due process violation is here. He's not arguing any prejudice for the 11 months. He did not ask the district court to return a verdict within that 11 months. In fact, he let the district court take its time. So right now, to second guess why would be, I believe, not the right thing for this court to do.
Am I correct that after the trial and before the verdict, stand your ground came up?
It did, Your Honor.
And so would that have caused some of the delay? Did the judge, was a motion filed regarding the stand your ground?
Yes, a motion was indeed filed regarding stand your ground to be applied to this case. The district court did decide on that motion and did say that it did not apply. It wasn't retroactive to this particular fact pattern. And as this court has held in Williams, that is not an issue in terms of retroactivity.
Right, but I was wondering if that was during that 11-month period that was raised and decided.
Yes, Your Honor.
Hypothetically, if Mr. Fordyce had been a police officer, would his use of deadly force on these facts been justified as a matter of law?
Again, Your Honor, that would have to be taken on the facts of this case. If he was a police officer, again, there will be a question asked: was his conduct here by not stepping back, by not de-escalating? This is someone who is not armed, can be making language that is probably to some extent of saying things to him. Just going ahead and shooting him would be perhaps, I would say, not justified. That the officer would have to be told that that was not reasonable conduct in this particular instance.
In my mind, a difference with an officer would usually be in uniform, and I think most everyone knows they're armed, whereas the defendant in this case may not have been known. Is there any evidence that he pulled his gun at any point prior to immediately shooting?
There is evidence to the extent where we know that Mr. Harrington does say, shoot me then. We also do know that defendant's sister says he has a gun. What are you going to do about it? When he's talking to Harrington, this is before he fires the shot. So we know that at some point there's a gun out.
Perhaps knowledge because of that comment, but is there any evidence that anyone saw something before he immediately shot?
The district court does find that he removed his gun at the moment, I believe at some moment just before he shot him. We do believe that in viewing the evidence in the light most favorable to the state, which is what this court must do in this particular case, we should affirm the district court's verdict that Mr. Fordyce continued the incidents when he came back, and that he had an alternative course of action, which would have started from the moment he left, to him coming back, to him getting his sister, to him going to the presence of the guy, and to him not leaving when Donald was agitated and moving from the porch towards him. We will ask this court to affirm Mr. Fordyce's conviction. Thank you.
Thank you very much. Is there any rebuttal?
Yes, Your Honor.
Thank you. May it please the court. Judge, I want to focus on something real quick related to your questioning on the timing related to the filing of the motion and whether that could have affected the length of the delay. The stand your ground motion was actually filed August 23rd. The verdict order came down August 29th. We did not file the motion until after we were informed of the verdict and the time set for the verdict to be read in open court. So I just wanted to clarify that. Following up on a couple other matters that were specifically brought up by the state, also focusing on, no, there's no evidence at all that Mr. Fordyce brandished his firearm before pulling it out upon Donald charging him. None whatsoever. Mr. Harrington was made aware that Mr. Fordyce had a gun because Mr. Fordyce's sister made a comment to that effect. That apparently agitated Mr. Harrington and caused him to, I guess, become a little bit more angry. But there is no evidence in the record that discusses Mr. Fordyce in that incident pulling his weapon ahead of time. Also, the discussion related to the alternative course of action and having to show whether or not there was danger. This record is devoid of any evidence whatsoever of the state proving beyond a reasonable doubt that Mr. Fordyce would not have suffered some form of danger or the potential for bodily injury had he chose to take an alternative course of action. I'll go back to 2 to 4 feet. That is irrefuted, that is when and the distance at which Mr. Harrington was shot. Second,
Mr. Kragnes, we have the benefit that you tried the case, right?
Yes.
So, which is usually not the case, and so you're very, very familiar with it. I thought the evidence was that there were some shots that were fired at least 3 feet away was the evidence, and then there was clearly a shot that was fired in the 2 to 4 feet range. So maybe the shooting started earlier than 2 to 4 feet. Is that correct, or am I misunderstanding the record?
no, and respectfully, Your Honor, if I heard your question right, you said the shooting might have started at 3 feet. I would submit that falls within that 2 to 4 foot range. So therefore, it is very possible that first shot might have occurred at 3 feet. It might have occurred at 4 feet. I'm not, and I don't want to in any way, shape, or form try to misrepresent that I'm saying it happened at a distance shorter than it actually did. Some of what this was taking into account for was Mr. Fordyce actually retreating while this was occurring. So there is certainly a little bit of a gray area, but based off of the pattern, the soot patterns and whatnot, it was determined to be that 2 to 4 foot range. Your Honors, I'm incredibly, and whether I'm troubled by it doesn't really matter, but I am incredibly troubled by the argument put forth by the state that Mr. Fordyce's duty to retreat started at the point in time that somebody was yelling at him, and that there was a verbal altercation that happened. So the state is apparently putting forth to this court that citizens and potentially law enforcement officers, well, if somebody starts yelling at you where you are lawfully
Didn't the
located,
evidence show that he had his hand in his pocket on the gun? Do I have that right?
the evidence shows that I believe he had placed his hand on top of his weapon. Yes, Your Honor.
And doesn't that indicate to you that as soon as he placed his hand on top of his weapon, that he had some trepidation that something may happen? And at that point, wouldn't it trigger the duty to retreat earlier?
I don't believe so, not at all, Your Honor. In fact, I think when we are talking about citizens, again, that are lawfully carrying their firearm, if we're going to make assumptions and presumptions, we're going to talk about their training. And at a point in time that you are carrying a weapon under the laws of the state of Iowa, you have taken training. You have assured this state that you're going to handle that gun responsibly. It would be, in fact, irresponsible not to know where your firearm is and what is going on at that point in time. And no, I don't believe that should have to cause you to retreat. Does that mean just because we have open carry now, does that mean if you are openly carrying your firearm and somebody starts discussing, yelling, road rage, whatever, you're supposed to just back away? I think we can't lose sight of the fact that Mr. Fordyce didn't do anything to increase this situation. His presence was there. That's what he did. That should not be unlawful when he's sitting on his sister's property. I see my time is up unless there's any other questions. Thank you, Your Honors.
Thank you both very much. The case of State of Iowa versus Fordyce is now submitted, and we're ready for the argument in Youngblood v. Youngblood.